Okay, to continue, let me share my screen again. Okay. Now, if you go into the jurisdiction of the court in order to determine whether the court has jurisdiction over the subject matter of the offense, then you have to go to the penalty imposable by law. Now, if the penalty imposable is more than 6 years, then you go to the regional trial court. Otherwise, you go to the municipal trial court or the first level court. Now, what determines the jurisdiction of the court is the extent of penalty which the law imposes on the crime, except in cases of the Sandigan Bayan. Now, the jurisdiction of the Sandigan Bayan class is a special court, is not based on the penalty provided by law, but on the salary grade of a public official. The jurisdiction of the Sandigan Bayan is based again on the salary grade. If the salary grade of the public official is 27 and higher, then you go file the complaint in the Sandigan Bayan. If the public official has a salary grade of 27 and higher. In libel cases, the jurisdiction is with the regional trial court, although the penalty imposable is not exceeding 6 years. Now, those offenses cognizable by the family court where the determining factor is the minority of any of the parties. Now, if the offended party is a minor, then you file it with the regional trial court designated as a family court regardless of the penalty imposable. Now, the offense of slight physical injuries is cognizable by the first level courts, but where the victim is a minor, the case is to be filed before the regional trial court. Take note of that. Now, number 5, lack of authority of the officer to file information. Okay. So these are the persons who are authorized to file the criminal action. Provincial fiscals, no? Okay. The chief state prosecutor, the Tanod Bayan, and his deputies in special cases, and then a lawyer appointed by the Secretary of Justice. Okay. Okay. Now, there are instances where, what are the instances, rather, where there is an unauthorized filing of an information? If the officer is irregularly appointed, it does not necessarily invalidate the information if such officer may be considered as a de facto officer. If the officer filed the information without the approval by the head or the city prosecutor, okay, or if the information is filed without the complaint in cases involving private crimes. Okay. An infirmity in the information caused by the lack of authority of the officer signing it cannot be cured by silence, acquiescence, or by express consent. An invalid information is no information at all. No criminal proceeding may prosper therefrom. Thus, it is subject to quash. Okay. Now, let us distinguish between pardon and amnesty. Now, kasi one of the grounds in filing a motion to quash is when there is an extinction of the criminal action or liability, meaning the criminal liability had already been extinguished. Now, one of the modes by which a criminal liability can be extinguished is through pardon and amnesty, rather. So, but these legal terms are different with each other. So how do we distinguish between pardon and amnesty? A pardon is granted by the president. An amnesty, rather, on the other hand, is proclaimed by the president, but it has to be with the concurrence of Congress. So in pardon, it can only be done by the president, while amnesty by the president and Congress. A pardon is a private act which must be pleaded and proved by the person pardoned because the courts take no notice of it. But an amnesty is a public act which the courts have to take judicial notice of. A pardon is granted after conviction, while amnesty, now even if there is no conviction yet, it can be granted to classes of persons or communities who may be guilty of political offenses before or after the institution of criminal prosecution, and sometimes even after conviction. So pardon, it can only be granted after conviction, amnesty before or after institution of the criminal prosecution, and even after conviction. A pardon relieves the offender from the consequences of the offense of which he is convicted. It only serves as a relief from punishment. So if a criminal has been pardoned, he is still a convict. He remains to be convicted of a crime, except that he will no longer serve his punishment of imprisonment. On the other hand, in amnesty, it will obliterate, it will abolish both the offense itself and the penalty. It is as though the offense had never been committed at all. Now, there is what we call as double jeopardy. What are the elements of double jeopardy? One, it attaches only upon a valid indictment or a valid information. Two, before a competent court. Three, after arraignment. And four, when a valid plea has been entered. And five, when the accused was convicted or acquitted, or the case was dismissed or otherwise terminated without the express consent of the accused. So memorize these elements of double jeopardy. Take note, class, that a double jeopardy can attach only after arraignment. Without arraignment, there can be no double jeopardy. Okay? Now, how do we distinguish a motion to quash to a demurrer to evidence? Class, a demurrer to evidence is also in the nature of a motion to dismiss, just like a motion to quash. The only difference is that in the demurrer to evidence, the accused is arguing that the prosecution failed to present adequate evidence. There is insufficiency in evidence. In motion to quash, the accused is hypothetically admitting the information, but he is presenting a fact which may be a matter of defense. It will prohibit the court from further hearing the case. So those are that is the basic distinction between a motion to quash and a demurrer to evidence. A motion to quash, the accused is hypothetically admitting the allegations of the information, but he is setting up a defense. But in a demurrer to evidence, after the prosecution has rested its case, then the accused is asking the court to dismiss the case because there is insufficient evidence. Now, a motion to quash generally can be filed before defendant enters his plea, while in a demurrer to evidence, it can be filed after the prosecution has rested its case. A motion to quash does not go into the merits of the case, but is anchored on matters not directly related to the question of guilt or innocence of the accused. On the other hand, a demurrer to evidence will deal directly with the evidence adduced by the prosecution in support of the accusation. Now, Rule 117 is governed by motion to quash, rather, is governed by Rule 117 of the Rules of Court, while Rule 119 governs the demurrer to evidence. A prior leave of court or permission of the court is not required in a motion to quash, while the demurrer to evidence requires leave, or it can be filed also without leave of court. Now, if the court sustains the motion to quash, then the accused remains in custody if at the time he is under detention unless he is admitted to bail. If no order to that effect is made, or if so made, no information is filed within the specified time in the order, okay, the accused may be set free unless he is also detained by other reasons. Okay. Now, if the motion to quash is sustained Upon any of the following grounds, the court must state in its order granting the motion that the release of the accused if he is in custody or the cancellation of his bond if he is out on bail, that the criminal action or liability has been extinguished, that it contains averments which, if true, would constitute a legal excuse or justification, or that the accused has been previously convicted or acquitted of the offense charged. Okay. Now, as a general rule, if the motion to quash is granted, no, or sustained, it will not prohibit or prevent another filing of case for the same offense. In other words, the prosecution can refile the information in court. So what are the exceptions to the rule that the prosecution may still file another complaint despite the grant of a motion to quash? Kasi class, if a motion to quash is granted by the court, then essentially the case is dismissed. Huh? Now, if the case is dismissed, question, can the prosecution file another information for the same offense? Answer, yes. The prosecution can file the same complaint. And the order granting a motion to quash will not prevent the filing of another complaint for the same offense. There are certain exceptions. 1, double jeopardy. 2, criminal liability is extinguished. So in these two instances, even if the motion to quash is granted, then the information has been dismissed essentially by the court, then the prosecution may no longer refile the information for the same offense. Okay? So there are different kinds of double jeopardy. 1, no person shall be put twice in jeopardy for the same offense. 2, when an act punished by law, an ordinance, conviction, or acquittal under either shall be a bar to prosecution for the same act. So again, memorize the requisites of double jeopardy. There is a there is a competent court that acquired jurisdiction over the subject matter. The accused was arraigned and entered his plea. So class, a dismissal and acquittal. No, if the court dismisses the case, it does not decide on the merits of the case. It does not say that the accused is guilty or innocent. On the other hand, if the accused was acquitted by the court, then it is an adjudication on the merits. The court is saying that the accused is acquitted because his guilt was not proven beyond reasonable doubt. Or the court can also say that the charges, the facts for which the accused can be was charged does not exist, or the acts or omission out of which a complaint or a criminal offense can arise does not exist. The court can say that. Now, dismissal, double jeopardy will not always attach in the dismissal of the case, but when the accused is acquitted, double jeopardy will always attach. Now, meaning the prosecution may no longer refile the complaint. Now, there are instances wherein even if the case is dismissed, it will not amount to an acquittal, no, of the accused. 1. Okay. Let me move my, okay. So let me rephrase. So there are instances wherein the dismissal of the case will amount rather to an acquittal of the accused. Meaning, if the court dismisses the complaint or the information, the accused is essentially acquitted. 1, insufficiency of evidence of the prosecution. No, if the accused filed a demurrer to evidence. And 2nd, dismissal due to violation of the right to speedy trial, even if dismissal was upon motion of the accused or with his express consent. So under these two grounds, if the case is dismissed, it will amount to an acquittal of the accused. Okay. Now, if For example, an accused is admitted as a state witness. For example, the prosecution needs vital evidence from one of the accused because sometimes the evidence could hardly be obtained. So if the accused will constitute, no, rather, if the government will constitute an accused as a state witness, then the order discharging an accused as a state witness will amount to an acquittal. Hence, double jeopardy will apply. No? However, if the state witness fails or refuses to testify against his co-accused in accordance with his sworn statement, and then he can be prosecuted again. Now, what is what we call as provisional dismissal? Now, class, there are two types of dismissal. One, provisional, and second, permanent. Provisional by its term means temporary dismissal. So what are the requisites of a provisional dismissal? One, there must be a motion by the prosecution with the express conformity of the accused, or by the accused himself, or by both the prosecution and the accused for a provisional dismissal of the case. Second, the offended party is notified of the motion for a provisional dismissal of the case. Third, the court issues an order granting the motion and dismissing the case provisionally. And fourth, the public prosecutor is served with a copy of the order of provisional dismissal of the case. Now, as a general rule, where the case is provisionally dismissed with the consent of the accused, he cannot invoke double jeopardy in another prosecution. Therefore, or where the case was reinstated in a motion for reconsideration by the prosecution, except, okay, the dismissal amounts to an acquittal even if with the dismissal, the dismissal was ordered as the instance of the accused if it is based on lack or insufficiency of evidence. Second, if the same was predicated upon the right of the accused to a speedy trial. Hence, even if the accused gave his express consent to such dismissal or moved for dismissal, such consent will be immaterial as such dismissal is actually an acquittal. And third, there is a variance between proof and the allegations in the complaint or information. So class, when does a provisional dismissal becomes a permanent dismissal? Now, if the case is not revived within 1 year after the issuance of the order of the provisional dismissal, with offense punishable by imprisonment not exceeding 6 years or a fine of any amount or both, no, then the case becomes permanently dismissed. So kapag ang offense is punishable by imprisonment not more than 6 years, then you have to wait for 1 year before the case becomes permanently dismissed. On the other hand, if the offense is punishable by imprisonment for more than 6 years, then you have to revive the case within 2 years from the issuance of the order of provisional dismissal. Otherwise, it will become a permanent dismissal. This is what we call as the time bar rule. Okay? Okay. However, if it is a justifiable reason for the delay, then the state may revive the criminal case even if the revival was done beyond 1 year or 2 year period. No? And of course, subject to the right of the accused to object to the revival of the complaint. Okay. So take note, class, that the reckoning period of 1 year or 2 year is from the issuance of the order of provisional dismissal. Then dismissal shall become automatically permanent if the prosecution fails to revive it within the required period. Okay? And then when the case has been permanently dismissed, such dismissal will amount to acquittal of the accused. So this ends Rule 117, motion to quash. I'll see you again on the next meeting. Thank you.